Let us talk for a minute about introducing evidence during the course of the ABA arbitration tournament. Now, even for students that have taken a full course in evidence, the rather stilted procedures by which you may introduce evidence or introduce a document into evidence during the course of an arbitration hearing is unfamiliar to law students. That's fine. There's no reason that it has to be familiar. It's actually a very simple process. I'm going to walk through the steps of introduction of a document into evidence right now. The key concept to keep in mind that a witness under oath testifies that a document is what it appears to be, that it is authentic, and that that witness recognizes the document to be a correct copy of the document. And that is the evidentiary requirement in a nutshell, that a witness under oath authenticate the document. I think of it as a rather simple three-step process where you show a piece of paper to the witness. You ask the witness to describe what it is. If it is familiar to the witness, if that witness wrote it, or if perhaps it was sent to the witness. And step 3, tell the panel of arbitrators that you would like to introduce the document into evidence. At that point, be sure you have copies that you can distribute to the other side, to the arbitration panel, and to keep a copy for your use during the continuing examination of your witness. Let's walk through what this will sound like. I'm conducting a direct examination of a witness. I've asked the arbitration panel if I may approach the witness, so I've walked up to the witness stand and asked and handed a piece of paper to my witness. Ms. Smith, do you recognize this document? She says yes. Then I say, what is it? And the witness describes what it is. This is a letter addressed to Joe Smith. Did you write it? The witness may say yes. I may ask, depending on what this document is, did you send it, or did you receive this letter? And the witness will describe, yes, I wrote it, yes, I sent it, yes, I received it. So the witness testifies as to the authenticity of the document when you ask, is this a true and accurate representation of the, whatever it is, of the letter that sent to you by the ABC company, or your letter, or whatever it is? And of course, the witness will confirm yes. Now, once the witness says yes, that is exactly what it appears to be, and this is an important phrase, that it is a true and accurate representation of the document itself, you thank the witness and you turn to the arbitration panel and say, I would like to enter this document as claimant's exhibit number 4, or whatever is the next number or letter in the series of exhibits that you are helping the arbitration panel keep track of. Now, a good arbitrator will certainly ask the other side if there are any objections. The other side examines the document. Perhaps they say no objections, and the arbitrator says, very well, let's mark it as Respondent's Exhibit C, or whatever. What if the other side does have an objection? Now, in the years that I've been coaching for this tournament, I've never seen a truly objectionable piece of evidence that is included in the record, the set of documents, the case record. But you may want to push ahead to confirm the authenticity of any document. Now, switch sides. Suppose the other side introduces a document through its witness, and the arbitrator then turns to your side and says, are there any objections? You might say something like, yes, Ms. Arbitrator, we would like to ask the witness about this document. the arbitrator will certainly allow it. You would say something like, this document is not dated or time-stamped. When did you write it or receive it? You can ask a short series of questions about the document, about its authenticity. If you notice that a date is missing, it's not time-stamped. If it is handwritten, you can certainly ask to confirm any aspect of the document. At which point you might say, we have no objection to this document, and the arbitrator will then rule, very well, let's mark it as Respondent's Exhibit C. And the hearing rolls on.